Judgment in the matter of Scotch Whisky Association and others versus the Lord Advocate and another.
The Scottish Parliament has decided to address detrimental health and social effects arising from excessive consumption of cheap alcohol, and suffered in particular by drinkers consuming to a harmful or hazardous extent and living in poverty in deprived communities. It has decided to do this by a minimum pricing regime as opposed to an imposition of excise duty or tax, and it has enacted the Alcohol Minimum Pricing Scotland Act 2012 for the purpose. The minimum price is to be set by secondary legislation, but the current proposal is that it be 50 pence per unit of alcohol. The 2012 Act contains a requirement for Scottish ministers to evaluate and report to the Scottish Parliament on the operation of the regime after 5 years, as well as a sunset clause terminating its operation automatically after 6 years, unless the Scottish ministers, by order affirmed by the Scottish Parliament, determine that the regime should continue. The entry into force of the 2012 Act has been delayed, pending a challenge to its lawfulness by the present appellants, who are the Scotch Whisky Association and other sellers of alcoholic drinks. The only live ground of challenge now is that minimum unit pricing is contrary to European Union law. This challenge has two limbs, since the regime is said to conflict with, first, Article 34 of the Treaty on the Functioning of the European Union, which prohibits quantitative restrictions on imports and equivalent measures, and second, Regulation EU number 1308 of 2013, which establishes a common organisation of the markets in agricultural products, which include wine, that is the single CMO regulation, and the common agricultural policy, which is set out in Article 39 of the treaty, CAP. The challenge has been rejected below, first in the extra division and then on appeal in the first division of the Inner House. Before rejecting the challenge, the first division submitted various questions to the Court of Justice of the European Union and received that court's answers. Those answers inform the Supreme Court's judgment. The Supreme Court unanimously dismisses the appeal. Lord Mance gives the judgment with which the remaining 6 justices agree. The 2012 Act does not breach EU law. Minimum pricing is a proportionate means of achieving a legitimate aim. The Court of Justice assimilated the issues arising on the two limbs of the challenge. It is common ground that the proposed minimum pricing regime will have effects in restricting imports and competition. The essential question is whether the restrictions on imports and/or on market competition are justified by reference to the regime's objective to protect human life and health. Under Article 36 of the treaty, proportionate restrictions with that objective in view may be justified. It is in that light also common ground that the objective pursued by the regime is in general legitimate and appropriate, although there is some disagreement about its precise implications and target. The Advocate General suggested a 3-stage proportionality analysis under the heads of appropriateness, necessity, and a balancing of interests. The Court of Justice spoke, however, of a 2-stage analysis consisting simply of appropriateness and necessity, but did suggest that some element of balancing entered into the 2nd stage. The Court said that a national court should examine objectively whether it may reasonably be concluded from the evidence submitted by the relevant member state concerned that the means chosen are appropriate for the attainment of the objectives pursued, and whether it is possible to attain those objectives by measures that are less restrictive of the free movement of goods and of the CMO, the Common Market Organisation. The objective, as it was put before the Court of Justice, was twofold: reducing in a targeted way both the consumption of alcohol by consumers whose consumption is hazardous or harmful, and also generally the population's consumption of alcohol. However, the aim was not that alcohol consumption be eradicated or that its costs should be made prohibitive for drinkers generally. The aim was to strike at alcohol misuse and overconsumption, manifesting itself in particular in the health and social problems suffered by those in poverty in deprived communities. The main area of contention is whether an excise or tax would be a less restrictive and equally effective way of achieving the Scottish Parliament's objectives. The appellants submit that an excise or tax would have a less restrictive effect on imports and/or market competition than minimum pricing, and the respondents have not really suggested the contrary. The Supreme Court is ready to accept also, contrary to the view on which the courts below proceeded, that the relevant European Union directives would permit additional excise duties or VAT levied at different rates by reference to narrowly defined different bands of alcoholic strength. However, the Supreme Court concludes that an excise or tax would not constitute an equally effective way of achieving the regime's objectives. In agreement with the Lord Advocate, minimum pricing targets the health hazards of cheap alcohol and the groups most affected in a way that an increase in excise or VAT would not. The latter would be felt across the board in relation to the whole category of alcoholic products to which it applied, and would unnecessarily affect groups which are not the focus of the legislation or the Scottish Parliament's objectives. Second, and again in agreement with the Lord Ordinary, minimum pricing is easier to understand and simpler to enforce. It would not be open to absorption, for example, by selling alcohol below cost in order to attract other business onto premises. Finally, the Supreme Court observes that it is unclear, so far as concerns any balancing exercise, how far an objective which is reasonable and can only be achieved in one way can or should be balanced against an assessment of any damage which, giving it effect, might cause to the ordinary operation of the European Union market. However, the fact that the Court of Justice suggested only a two-stage analysis and did not endorse the Advocate General's suggestion of a separate third stage involving a balancing exercise indicates that any such exercise should be treated very lightly. Any such comparison is between two incomparable values. On the one hand, health, and on the other hand, the market and economic impact on producers, wholesalers and retailers of alcoholic drinks across the European Union. The court should not second-guess the value which a domestic legislator puts on health. As such, there is also limited scope for the criticism made by the appellants about the lack of European Union market impact evidence. Such analysis of the market and competition impact as is available demonstrates that the impact will be minor. The submission that the Scottish Government should have gone further than it did to assess market impact is not realistic. The sunset clause, indicating the provisional nature of the regime, is also a relevant factor in favour of upholding it, as the Court of Justice itself said that it could be. The appeal is for these reasons dismissed. The Court will adjourn.